Greetings to you members. Welcome back to Agora Legis, the platform of legal minds where we discuss legal principles and make them easy to understand. We are winding up with Contract Law 1 with the topic of exemption clauses, otherwise called exclusion clauses. We shall be looking at the meaning of this concept. We shall be looking at the rationale of this concept. We shall look at the rules and framework governing exclusion clauses, and lastly, the incorporation of exclusion clauses. So without further indulgence, it's Counsel Ben at Agora Legis, and let's jump right in. And by definition already, according to Chris Turner in his book Unlocking the Law of Contract, the 4th edition, an exclusion clauses or an exemption clause is defined as a term inserted into a contract with the purpose of relieving one party from liability which would otherwise arise. So this is a term in a contract that comes to exclude liability or to relieve one party from liability. It comes to remove the liability that would otherwise arise to a party in a contract. But now, let's say for example, in a contract where you are buying a phone, but the seller writes in the contract that in case of any defect in the phone, it won't be returnable. So that means that the liability that he would otherwise have of getting back the phone with defect won't arise anymore because of an exclusion clause. If you read that exclusion clause and agreed to it, it becomes binding. In understanding the nature of an exclusion clause, there are some certain concepts or some certain terms which we should not confuse while talking about an exclusion clause. And the first one is a limitation clause. What is a limitation clause compared to an exclusion clause? While the exclusion clause comes to eradicate or remove totally a liability that would otherwise arise, a limitation clause comes just to place a ceiling on the recoverable amount in case of any liability that would arise. For example, if in a contract it is stated that the supplier's liability shall not in any circumstance exclude 5 million Ugandan shillings, that means that whatever comes out, if he is to compensate you for anything, and as long as you have agreed to that contract and signed under that exclusion clause, the liability that he will have will not exclude that particular amount. So the second concept not to be confused while talking about an exclusion clause is what we call a disclaimer. What is a disclaimer compared to an exclusion clause? So a disclaimer is a statement that is made to clarify something about the nature of a given thing or a given fact or a given relationship that people have that would otherwise be ambiguous, and is only showing the clarity of things about the nature of that thing. For example, if I'm to take a live example here at Agora Legis, the content at Agora Legis does not amount to legal advice, but is only for educational purposes. So anyone who would rely on the content here to undertake legal activities or to undertake legal proceedings, in case there is any gap in the way he is proceeding, I would not be liable at Agora Legis. Why? Because there is already a disclaimer. So a disclaimer is not an exclusion clause. While an exclusion clause exclude liability in a contract, a disclaimer is only there to elucidate or to make it clear about the nature of the things that are being undertaken. In third position, an exclusion clause should not be confused with an indemnity clause. What do we call an indemnity clause? This is a term in the contract whereby one party agrees to bear the costs or to protect the other party from any loss or damages. For example, if you are entering into a contract with a graphic designer to make a logo for you, for example, and the graphic designer puts in the contract that the logo that I will make, in case it infringes on the trademark of another company, I would be liable for that. So he will bear the losses for everything that comes out as expenses to incur as a result of that of infringement on that trademark of the other company. So this is what we call an indemnity clause. So members, after understanding the concept of an exclusion clauses and what the exemption clauses mean, we shall now look at the rationale or the reasons why we have the principles on exclusion clauses. So the first rationale is allocation of contractual risks. Secondly, we have it reduces the exposure to damages in a contract. And lastly, of course, securing the parties' interest in the contract. So the parties want to make sure that their interests in that particular given contract are secured and won't be tampered with in any situation that may arise. Third point of discussion, members, we have the rules governing exclusion clauses or application of exemption clauses. So the first point to have in mind is that this principle is based on the principles of freedom of contract or consent in a contract as provided for under section 12 of the Contract Act Cap 284. So whereas much as the parties have this freedom to enter into a contract and to agree on the terms that fit them the most, there are some principles that will govern these exclusion clauses. Not every exclusion clauses will be applicable and will be binding in that particular contract. Firstly, members, we have the Contra Proferentem Rule, which is to the effect that these particular exclusion clauses shall be used against the parties which intend to use it or which introduces it and intend to rely on it. This has been applied in the case of Counsel versus William in Uganda, and the court established that the Contra Proferentem Rule shall be used against the party which introduces it in case of any ambiguity. Secondly, we have the rule against fundamental breach, which is to the effect that an exclusion clause shall not be applicable where it is upholding a fundamental breach to that contract, which is even affecting the main purpose of that contract. For example, in a contract where we are agreeing to me to buy a phone, for example, if the seller puts a clause in the contract that he shall not be liable for anything that happens if I don't receive the good as we contracted for, that will not be applicable and that will not be binding as a term in a contract, because it is touching the very purpose for which we are contracting, because the consideration that I'm waiting for is to get the phone and him to get the money. So in case the exclusion clause here upholds a fundamental breach in the contract, it does not apply, and which is one of the rules governing exclusion clauses. Third position, we have the rule for reasonable notice. It is to the effect that a party who intends to put an exclusion clause in a given contract has to give reasonable notice to the other party. So the other party has to be aware of what that clause is to, or that clause is to what effect. So this has been applied in the case of Oliver the Marlborough Court Hotel, whereby the exclusion clause that the hotel intended to rely on was not reasonably noticeable by the client or the customer, and as such the court could not rely on it, and it was liable for the loss that Mrs. Olay incurred in that particular case. Lastly, as per the rules governing exclusion clauses, we have the rule against illegality. So an exclusion clause should not uphold an illegality in the contract. It should not put in evidence, or it should not support the application of an illegal action or illegal fact in the contract. For example, if we are contracting to buy or sell goods, and in the contract I put a clause that even if the goods are sold by fraud, for example, I will not be liable for anything. So that would not apply, since it is an exclusion clause that is upholding illegality, because the contract has to remain lawful. At this point of our discussion today, members, we are going to look at incorporation of exclusion clauses. And here we are going to look at how is an exclusion clause put into a contract, how is it inserted into a contract, and when does it become effective and binding to the parties of the contract. And in first position, we have incorporation by signature. So an exclusion clause is incorporated in a contract once the parties to that contract have signed and agreed to signed on that particular contract. And as it was seen in the case of Estrange vs. Crocop Limited, the plaintiff had signed a contract containing an exclusion clauses without reading it fully, and she was bound by it since she had already signed, and the exclusion clause had become effective and binding upon her. Secondly, we have incorporation of exclusion clause by reasonable notice. This is to the effect that once an exclusion clause is reasonably noticeable by the other party, the presumption is that the other party had the opportunity, and a reasonable opportunity, of consulting it and consenting to it before agreeing to enter into the contract. So once the exclusion clause is reasonably noticeable, the presumption and the court shall assume that the exclusion clause was reasonably noticeable, and as such it was incorporated duly. Lastly, members, we have incorporation by ordinary dealings or ordinary course of business. This is to the effect that the parties which usually contract together and deal in a certain way, and they usually use a given exclusion clause in their future agreement of the same nature, the court shall presume that the same exclusion clause applies even if not stated, and it shall be implied that they were bound by that particular exclusion clause. And that is it for today, members. We have appreciated the principles on exclusion clauses in Contract Law 1, and by that we are closing this course unit, and we shall be continuing with the principles in Contract Law 2. I hope you have grasped the principles. In case of any question, do not hesitate to comment down there, to like, subscribe, and share, because that is the only way you are going to uphold this mission that we are having of academic excellence at law school. Thank you for watching. It is always Agora Legis with Counsel Ben.